Good afternoon and Happy New Year. Welcome and thank you for joining us for the final session of our Community Associations Building Blocks webinar series. Today's session will cover the topic of community drainage, flooding, and architectural control parameters. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Warden Smith, and I'll be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Our speakers today are happy to take questions after the webinar. If you have a question, please type it in the Q&A box and it will be addressed at the conclusion of the presentation. Let's get started with our speaker introductions. Today's speakers are Amy Wayne and Eric Remington. Amy leads the firm's environmental practice with a focus on the environmental aspects of real estate and business transactions, including coastal development. Additionally, Amy chairs Warden Smith's Green Initiative to build and promote environmentally sustainable professional practices within our firm. Eric's practice experience encompasses various areas of civil litigation, including real property, business and commercial litigation, zoning and land use issues, disputes involving community associations, and insurance coverage disputes. He's a member of the Zoning, Planning, and Land Use Section Council of the North Carolina State Bar Association and leads the firm's eminent domain practice. I'll turn the mic over to Amy and we can begin.
Great, thanks, Jen. Welcome, everyone. As Jen mentioned, I'm an environmental attorney with Warden Smith, and I work with several of our community association attorneys, like Eric, to provide services to our community clients and their property managers. Many of those services within the last 5 to 7 years have involved dealing with issues created by stormwater in our various communities. Over the last several years, no matter where you are in the state, I'm sure you've experienced rain events that seem to have greater impacts in your community more than they used to. And today we're going to take a broader view of stormwater and place it in context with drainage and localized flooding issues that are faced by many of our clients. All of this typically begins with a developer's idea and the developer's plans for a community. The development typically begins with construction plans for the community. And for our purposes today, the ones that really count are drainage plans to direct the flow of water throughout the community, erosion and sedimentation control plans, which are designed to contain and manage loose soil during construction activities to keep them from washing into surface waters from those land disturbing activities, and construction stormwater permits, which also address controlling soil and sediment from washing off the construction site during and after rain events and keeping it from getting into surface water. That's the construction phase. When the development's completed, post-construction management of surface water flow, whether it's drainage or stormwater, is accomplished through different provisions and permits, sometimes in covenant languages, easement agreements. Any of those in association will need to understand how they work together and understand the terms, not only for common area that the community association may own itself, but also to manage activities within its authority in the community that are outlined in its governing documents. So although this begins with the developer's plans, it's going to end with your association's management of that completed development in the community. Let's take drainage. Its primary focus is to plan for the direction and flow of water during construction and after the build out of the overall community. It's primarily a local concern, and it's governed by ordinances and building permit schemes within a county or the city that has jurisdiction over a drainage basin, which is comprised of local rivers and tributaries, where the development activity is occurring. Plans for drainage have features that address the surface water direction of flow after grading for the planned community and after the completion of development. It allows some predictability for the surface water flow from rain events or even from man-made irrigation. And it also manages the ability for the drainage basin system itself to store water, particularly in the eastern part of the state, Our drainage basin catches a lot of our surface water relatively quickly because our water tables here are so high. Stormwater, on the other hand, has a different impact on the community, and the regulatory schemes have a different purpose. So although stormwater looks similar to drainage in that most often it's generated by a rain event, and that rain event creates surface water flow, the regulation of stormwater has a different goal. Stormwater management is intended to prevent pollutants that are in the flow from impacting surface water resources, whereas drainage plans address the volume and the direction of flow, but not what's actually in the flow. So at the beginning of the construction activities, the erosion and sedimentation control plans and construction stormwater permits that I mentioned, and also post-construction stormwater permits, they're actually part of a broader scheme that originates at the federal level with the Clean Water Act, and its purpose is to protect water quality. That scheme and its implementation is delegated to or implemented by states, including the state of North Carolina. And further down, it's also implemented by certain localities, usually in larger municipal areas. So as you can see, it's easy for an overlap of stormwater and drainage to occur, both in how we may see it just on a daily basis in our lives, but also in the regulatory controls that affect how things are managed. This overlap can occur if a locality governs both stormwater and drainage in its code of ordinances or a unified development ordinance. But each of those, drainage and stormwater, will be addressed in different sections of the ordinance because they're not the same. The other overlap that occurs is between state authority and local authority over stormwater. So as you can see from the slide, your stormwater regulations may come at the state level through a state stormwater permitting program, or there may be a program in your local ordinances. The stormwater permits are administered by the North Carolina Department of Environmental Quality, the Division of Energy, Mineral, and Land Resources, or DEMLR. Many of you on the call today might be familiar with them. Or you might have, your governing authority might be your local county or city planning department that's charged with implementing stormwater ordinances in their local ordinances, or depending on the size of the city, larger cities even have their own stormwater units. Then the actual authority, or what's going to guide what happens and what's required on a daily basis, is either going to be in your state stormwater permit, the actual permit terms themselves, or they may be in a recorded easement agreement between the original developer and the municipality. It may be in the covenants as well. And those will all address in some shape or form, built upon area limitations to control the amount of impervious surface that's allowed in the community, the operation and maintenance of any stormwater controls, bonds that may be posted that the city requires. And sometimes there's a blending of language between stormwater and drainage in some of those easement agreements. There are different enforcement mechanisms depending on whether the obligations are in a permit, that is a standalone permit, or whether it's a recorded agreement that has land use restrictions in it that run with the land. So in other words, once the land changes hands, it automatically binds the successor owner, whereas a permit itself is a contract between the state agency and the developer, and those obligations don't pass until a transfer actually happens. So while there may be state and local stormwater regulations, there isn't a statewide drainage regulation scheme. So you may see a lot of overlap between stormwater being addressed at the state and local level, but your drainage is only going to be addressed at the local level. This is part of why the concepts of drainage and stormwater and localized flooding get conflated, and it can be very confusing when you don't deal with this on a daily basis. And you will see some of this confusion within and among your community members. So concentrating just a little bit on the stormwater right now, like I just mentioned, it can come in a couple of forms, either at the state level or the local level. If you are governed by a state stormwater permit program, you'll know because your location is going to trigger whether or not your community is part of a state stormwater program. For example, there's a coastal stormwater program for the 20 coastal counties. Something else that will trigger the need for a stormwater permit is the need for an erosion and sedimentation control plan approval, which I mentioned earlier at the beginning of our webinar. And that's usually triggered with just an acre of land disturbance. So those will automatically require the stormwater permits. In the 20 coastal counties, if there is a requirement for a CAMA major permit, you'll need a stormwater permit. And throughout the state, your proximity to protected water resources will also trigger a permit. There are different programs for trout waters. The state stormwater program also covers outstanding resource waters and high quality waters that are more frequent to the west of 95 outside of the 20 coastal counties, and also SA waters or shellfishing waters, which are east of 95 in our coastal counties. The regulations and terms of the permits protect those receiving waters by limiting the amount of built upon area or impervious surface that replaces a green space so that there's enough remaining soil to do a couple of things to try to protect water quality. Keeping enough green space or soil around helps to control the velocity of runoff. You'll notice in your own community that when it rains, it sheet flows off of your streets and your driveways fairly quickly, but it doesn't have the same velocity running through lawns or green spaces. That allows the water to slow down enough to allow it to start to infiltrate into the vegetation and to allow the soil to capture the pollutants. That's the primary purpose of the stormwater regulations. And at a certain point, engineered stormwater controls might be required and combined with those built upon area limits to treat stormwater. So on the side, you can see, for example, in a low density community, a community that allows, depending on where you are, between 12 and 25% of the area is not developed so that you have enough green space to allow that infiltration to occur. In these communities, you may have a stormwater permit, but there's no expiration on it. It's a perpetual permit. There are no engineered stormwater control measures that are required. It's mostly vegetative swales without piping. Those are what you would see. They look like ditches along front yards. Those are the swales. And then built upon area limitations, which limits the amount of impervious surface can go on either individual lots, per lot or per grouping of lots. And then there's also an overall community built upon area limit, which is usually a percentage. And those work in tandem to try to manage the stormwater and the pollutants that flow with it. There are also easements that are required. Common area is owned by the community, but then there are also the community association, but there are also easements that the stormwater permits often will require, sometimes between lots or more frequently at the front of a lot, maybe where the swales are, to allow for those with the authority to make sure that the stormwater can actually get into those swales and those swales function the way they're supposed to. Other communities are higher density communities. These are communities where they may have built upon area limits for the lots, but they will also have engineered stormwater control measures. These are the most obvious ones are the ponds that you can see. Some of them are detention ponds that are designed to hold the water. Others are retention or infiltration basins. So they hold water for a while, and then they're supposed to allow it to infiltrate down into the soil. Those permits they do have an expiration date on them. They're valid for 8 years, and they must be renewed. And as part of that renewal, there are inspections that need to be done to make sure that the engineered measures have been operated, maintained, so that they are still functioning the way they were designed to control that stormwater flow. The built upon area limitations and some of the operation and maintenance terms that you see in the permits also very often are in restrictive covenants. In the older permits, sometimes the language didn't entirely mirror what ended up in the covenants, but in more recent permits, those permits at the state level are very specific as to what language actually needs to appear in the covenants, so that that language is identical. For a local stormwater permit, those permit programs vary by municipality, and they have the same purpose to protect water quality, but they're going to look different. And oftentimes they are not permits per se, but they are in the form of easement agreements. And that just varies by municipality across the state. So you might remember at slide 1 at the beginning of the webinar, I explained that all of this starts with the concepts of the developer. They are coming up with the design plans. They are getting the permits with the regulatory authorities. By the end of the project, the requirements of the stormwater permits are going to shift, or intended to shift, to the association through property conveyance and permit transfer, depending on where you are. If you are in a locality that has local easement agreements, those obligations will automatically transfer to the association when the property is conveyed to the association. If you are in an area where there's a state stormwater permit that governs how your stormwater is controlled, then there's actually a formal transfer process with that state permit. There are forms, you can find them on the agency's website, but it's essentially an application form to transfer the permit. Generally speaking, the permit's sort of right to be transferred only once common areas have been conveyed to the property owners association. If the declarant or the developer has turned over control to the association, or more than half of the homes in the community have been conveyed out from the control of the developer, that has to happen. And then also the agency needs to do an inspection and determine that the stormwater management system is in compliance with the permit conditions. So if you have a low density permit, they will come out and inspect, take a look at the swales, take a look at how things have been maintained. If it is a high density permit and there are engineered controls, they're going to take a look at the ponds. Have they been operated and maintained in accordance with the terms of the permit? There are lots of different types of stormwater control measures now also that have different design criteria, such as level spreaders, constructed wetlands, and they're going to take a look at all of those and need to confirm that what is in place is what was approved by the permit and that it's operating the way it's supposed to. And only at that point can the agency transfer the permit to the association. Now, there were new provisions that were approved by the General Assembly and then the governor in September of this past year to address permit transfers. And there are different windows of submission of the transfer request now, depending on when the transfer conditions were met. Prior to this past September, there wasn't a time that triggered when those permits were supposed to transfer to the association. And oftentimes what happened, and there may be many of you on the call today that have experienced this, is the developer would get all the permits at the beginning of the project, complete the project, and then move on to the next project and never transfer the permit, never go back to go through this process to confirm that what was designed and approved is what went in the ground and is operating as it was supposed to. And this has created a lot of headache for communities that are left with the situation that the developer left, for developers who have to now figure out what their obligations are in a community that they haven't had control over in years, and for the agency that now just had more of these issues than they knew what to do with. So the session law that went into play on September 16th set up provisions for these to address some of these issues. The ones that affect community associations the most are, there are probably two or three big ones. The first one is that annual certifications are now going to be required to show that the permit is in compliance, or that the stormwater control measures are in compliance with the permit. So for all new permits that the agency has been issuing since September 16th, there'll be a provision in the permit that requires an annual certification for a licensed consultant to come out, observe, and basically certify to the state that the stormwater system is in compliance with the permit. For permits that were issued prior to this fall, if the permits are reissued by either a renewal or a modification or a transfer, in any of those cases, there'll be an annual certification that's then required. And the compliance needs to be, that burden is on the permit holder or the permittee. So for associations, that means if the permit had been is transferred to the association, or it was transferred to the association in the past and for some reason needs to be modified, or in the case of high density permits that it needs to be renewed, those permits will then have an annual certification requirement. The lengthiest provision does address these transfer issues that were occurring, particularly in the case of an absent developer. So now there are provisions for transfers that require both the permittee, the developer, and the new permittee, and they have to join together to request the transfer. Transfers can occur without the consent of the permittee or successor owner if the permittee was deceased, or it was a company that was dissolved, or the property was sold. They can, if the successor owner holds title or the right to engage in the activity, or is an association, the agency can transfer the permit. If these requirements happen after July 1st of 2021, then those parties have 90 days from that time to request the transfer. If those events occurred prior to July 1st, then there are 180 days to request the transfer of the permit. We have yet to see what the agency is going to do when and if they know about the occurrence being met and the request hasn't gone in. But this, right now, these are the terms in the session law. If there are compliance issues that are identified by the agency before they complete the transfer, those compliance issues have to be resolved by the permittee and the permittee only. They're supposed to submit an action plan and a compliance schedule, and that has to occur before the agency will transfer the permit. So these are worth looking into and being aware of whether your community is under a state permit and is in the situation. The other two that are sort of smaller issues are for those stormwater, they were called certifications in the early years of stormwater permits. They were issued pre-1995. Those were revoked as of January this year. And the way the agency is going to treat those is to treat the existing built upon area as existing development, and they're going to go forward. So there's not going to be an investigation of whether or not built upon area limits and those stormwater certifications match what's on the ground. And then the other provision that will affect community associations is that for low density permits that were issued before 2017, if there is built upon area that is over the permit limit, then the agency will work with the permittee to do a modification of the permit to allow the discrepancy or the overage. If the overage is less than or equal to 110% of the permitted built upon area, the agency plans to issue a modified permit. If the overage is more than 110% of the permitted area, then mitigation is going to be required. So we'll have to see how that's all going to fall out. So as you can see, there's a lot of overlap between drainage and stormwater. I've been talking about it at the regulatory level, and whether it's between local and state authorities or state permitting regulations, local ordinances, your restrictive covenants. It also happens, the overlap happens at the relationship level between homeowners and the homeowners association, between homeowners themselves, neighbors. And it's going to continue to occur through a combination of those state and local laws and the community's governing documents. Restrictive covenants, bylaws, each of these things may be addressed separately or in combination depending on how your documents were drafted. And that can greatly affect how the association manages it, what the board has to consider, and what your architectural review committee may be looking at as well. So I've covered the sort of the regulatory blending of drainage and stormwater. This will transition now over to Eric, who's going to walk us through the legal doctrines of surface water and the options for how to manage this outside of your permits and ordinances. Eric?
Thanks, Amy. Good afternoon, everybody. Appreciate you all attending our presentation today. As Amy said, she deals with a lot of the front end issues with regard to stormwater or drainage and dealing with the rules and regulations that the state and municipalities impose on people who are modifying their land. What I'm going to talk to you a little bit about are the legal doctrines and rules that pertain to liability that results from those changes that are made to the surface water flow and drainage issues that may come up. As you all know, and as Amy has talked about, North Carolina and every other state in the United States allows landowners to basically change the flow of the surface water in their community. And the way that they do that, as Amy talked about, is that they start with a plan for a subdivision or a commercial development. And then there's grading that's done. They may change the vegetation from being a fully wooded tract of land to being basically a bare tract of land with buildings and impervious surfaces on it. And they also may alter natural waterways, streams or channels of water, and they may add drainage and things like that through those plans. And the result of that, all of that, can be that there are legal issues that arise, problems that occur between adjoining landowners and the land that has been developed. And so what I'm going to talk to you about are some of the rules that have been developed over time regarding those liability for those kind of issues. So there are several legal theories that govern the liability or flow of surface water that have developed over time. And those theories there's really three of them. The first one is called the common enemy rule. And the second one is the civil law rule. And then the third one is the reasonable use rule. And as you can tell from the labels of those rules, they're pretty self-explanatory. But I am going to talk to you a little bit about what each of those rules entails, and then tell you what North Carolina applies. So we'll start with the common enemy rule. Basically, what that rule says is that surface water is essentially a common enemy to all landowners, and courts treat it as such. So that landowners are able to, in those communities that adopt the common enemy rule, they're able to do what they want to or need to alleviate any kind of problems that they have. So for instance, you can do retention on your property. You can divert water from your property. You can do what they call repulsion of the water, or you can alter the transmission routes of the surface water. So those are all things that landowners in a common enemy rule state are allowed to do to basically control surface water. And what the result of that is that the courts find that there's really no liability to adjoining landowners when people make these changes. So those communities that adopt this rule have essentially said, well, we're going to place a higher value on the development and improvement of the property than we are on the problems that might result from that. And that's really based on two concepts that they've adopted that rule on. The first being that there's a necessity of improving the land. And with that comes an understanding that there's going to be some sort of damage that may occur as a result of the grading and changing of the land in order to do the development. And so that's kind of accepted as part of that rule. The second part is one of the basic tenets of real property law, and that is that there's a freedom of the landowner to basically deal with their land as they see fit, and that restrictions to land are not favored in the law. And so, as long as you're using your property in a manner that is essentially reasonable, then you ought to be able to do that, even if it causes some sort of damage to the other party. The next rule that came up was what they call the civil law rule. And basically in that rule, the landowner is liable. It's basically the opposite of the common enemy rule. The landowner is liable to the other landowner when the surface flow is changed and there is damage that is basically done to the other party's property. So if you have the natural flow of water is from one property to another, and what's called the upper property changes the flow of that water so that more of it is going on to the lower property, then the lower property would have a cause of action against the upper property. So North Carolina actually followed the civil law rule until 1997. And then the court did an extensive evaluation of that rule plus the other rules in a case called Pendergrass versus Aiken. And what that case entailed was basically you had the Pendergrass owned what, again, we call the upper land. They were at the higher altitude. And as we all know, water flows downhill. So they were the upper body tract of land. The Aikens owned the lower tract of land. And usually there's some problem with the lower land being flooded more from the upper land. But in this case, it happened to be that the Aikens ended up putting in a drainage pipe to basically divert the flow of water that was coming from the Pendergrass property and channel it so that they could make better use of their property. And then what they did was they installed a 36-inch wide pipe and then buried it under the ground. That pipe then went to a set of two pipes that were 24 inches wide that went under the street that was owned by the municipality. And what happened was the water was backing up from the Aikens pipe onto the Pendergrass property. And so the Pendergrass ended up suing the Aikens over that. And the question became, there was a jury instruction that was given that essentially talked about what at that time the court felt the rule was. And the Pendergrass felt that the instruction that was given was confusing, and therefore they appealed it. So basically what ended up happening was the court looked at all of these classifications, started by discussing surface water, the difference between surface water and water courses, which are channels and streams, and found that there was really no basis for making a distinction between the two, that whether it's rain coming from the sky or whether it's a water in a channel, all water, surface water, ought to be treated the same. And then they examined each of the rules and went through an in-depth explanation of each of those. And they noted that North Carolina, even though it had adopted the civil law rule, had a number of exceptions to that rule that they were already following. For example, when a municipality constructs a road or a street, oftentimes there's going to be runoff from the road or street that's going to end up affecting the adjoining lots that are next to that road or street. And what they found was that the addition of the road and construction of the roadway, as long as it was done using typical engineering techniques and was not negligently constructed, was essentially done for the public good, and that outweighed any damage that might be done to the adjoining landowners. So there was this municipal construction, street construction exception that was made. And so then they looked at also riparian rights, people that are next to a body of water like a stream or a river or something like that. And ultimately what they came up with was they adopted what they call the reasonable use rule, which is this third rule that had been adopted in a couple of states, but was not widely used at the time. And just to give you the exact language of the rule, basically what the court held was that each possessor of land is legally privileged to make reasonable use of his land, even though the flow of the surface water is altered thereby and causes some harm to others. But liability is incurred when the landowner's harmful interference with the flow of surface water is unreasonable and causes substantial damage. So that's that full rule as stated by the North Carolina Supreme Court. So what does that mean for a landowner? Basically, landowners can, in North Carolina, can make reasonable use of their property, even if it may result in some harm to an adjoining landowner. But it must be reasonable, and they must take reasonable care to avoid causing unnecessary harm to the other adjoining landowners. And if they do something that is unreasonable or negligent, then they can be held liable for the damage that's caused by the improvements that they've made. And finally, the court went on to say that in some cases, the gravity of the harm to the adjoining landowner may be found to be so significant that it requires compensation regardless of whether the conduct of the defendant was reasonable under the circumstances. And what the court found in the specific Pendergrass Aiken case was that the instruction that the judge gave to the jury combined the reasonable use rule with the civil law rule, and therefore it was improper. It gave the jury a mixed signal as to what it should be doing in that case. So what kind of factors does a court consider when they're looking at it and an issue like this, when there's a nuisance claim or other claim that's been brought as far as the discharge of surface water and flooding and things like that? Essentially, the court is going to weigh the gravity of the harm to the plaintiff against the utility of the conduct of the defendant. Okay, and some of the factors you can see on the slide there in determining whether the project is or the alterations to the land are reasonable or not is whether the action was intentional and unreasonable, negligent, or reckless. Now, all of the action that is taken to improve land is intentional. So there has to be something a little bit more than that than doing it intentionally, because if again, they've used reasonable engineering standards, they've gone through the proper approval processes and things like that, and they've had their project approved, and then they construct it according to the plans, then they're probably going to found to have made a reasonable use of their property. But it's where it's, they deviate from the plans, they don't get approval for plans, or, they make changes to the plans after they've been approved, that they can get in trouble. The court also looks at the again, the extent of the harm and the character of the harm that's been done to the plaintiff, as opposed to the social value of the use, or in other words, the purpose of the use. Why was this alteration of the surface water flow done? Another standard is whether the actions that were taken are typical or suitable for the locality. Again, if these types of changes are being made all throughout the community, then that's probably going to be a factor that the court is going to consider. So, that's kind of a community standard that they look at. And then the last factor that they really look at is whether the burden on the landowner to minimize the damage. There's the person that is making the change has a obligation to do what they can to minimize whatever damage is going to be done. So if there's a way to construct a pond in 2 ways and a drainage system in 2 ways, and one way is going to result in more runoff to the neighbor, and the other one's going to result in less, then the court's going to look at that and say, well, you probably should have put in the lesser damage one. So the action that can be taken, like Amy said, also depends on state and municipal laws, what governs that piece of property. You got to look at the local ordinances as to what kind of uses can be made of that property, and whether those are appropriate uses, whether there's any kind of easement agreements related to drainage or other water flow, whether there's utility easements of any kind, that kind of thing. And then the covenants and restrictions that apply to the property. Those are especially important, like Amy said, with the built upon area, classifications and amounts, because that's where, communities can get in trouble if the built upon areas on the lots are being exceeded by the builders that are in that community. So those are all things that need to be addressed and consulted when you're looking at whether there's liability for some sort of damage that's been caused by stormwater runoff or flooding of some sort. With regard to the covenants and restrictions, as you all probably are familiar with, covenants and restrictive documents, declarations are basically contracts, and they're going to be interpreted by courts using the same philosophies as the interpretation of contracts. And so a lot of times the language of those documents is going to be interpreted as a matter of law, where there's not going to be a whole lot of evidence that's taken on that issue. The court is just going to take a look at the language of the document and try to determine what the drafter meant at the time that the document was drafted and created. And in order to do that, the court basically looks at the 4 corners of the document. Lawyers are notorious for trying to pull things out of context and take one statement in a document and use it to support their case. But what the court is supposed to do is look at how all of the provisions of a document apply together to determine whether the language that is in question is ambiguous, or whether it's clear and should be applied the way it's written. And that's something that the courts do take very seriously. They do look at all of that, and they try to determine whether, reading one provision would make another provision be ambiguous. And that's what happened with the instruction, was that they found that there was one thing that the judge said in the instruction in the Pendergrass case, and then he said something that was opposite of that. And so it basically made the instruction to the jury confusing. That's a little, the instructions are not restrictive covenants, but it's the same kind of concept there. So the court can, determine what the rights and obligations of the parties are based on the 4 corners of that document. And then the court also has the ability, though, to find whether there are implied rights or obligations, because the court implies certain things from the language in documents, and we do have implied contracts, implied agreements. For example, I'll just give you one example of that in the HOA community area. Is there are cases in North Carolina that deal with implied contracts regarding assessments and things like that when there are no written assessments. Written covenants that allow for assessments. So you can have implied contracts within the HOA kind of community. However, the documents are typically strictly construed, and any kind of doubt is going to be resolved in the favor of the free use of land and against the restriction. So basically, it's interpreted against the drafter, which a lot of times is the declarant and his legal team. And, but typically the declarant is not necessarily involved in these disputes. It's usually a dispute between one lot owner and another lot owner, or lot owners and the HOA. So, but that'll be strictly construed, especially if the language is clear and unambiguous. Okay. So when can a HOA be responsible for drainage issues? The simple answer is that an HOA can be responsible for drainage issues. And a lot of times the covenants are going to be key in that area. Unfortunately, for litigation attorneys like me, it's hard to, give you a black and white answer on that because a lot of those issues are gray. There's a lot of factors that play in it. But ultimately, what I can tell you is that the covenants, the restrictive covenants, are going to be key to that determination. First of all, is the HOA responsible for the drainage system in the community because it is part of the common areas that are controlled by the HOA? If it is, then the likelihood that the HOA is going to be responsible for that is increased. I've had a community where there was a golf course in the community, and the golf course owner, which was a private company, was basically responsible for a lot of the drainage areas within the community because the developer who sold the golf course to the private company had never transferred the drainage areas to the HOA. And so when the HOA had, lot owners coming and complaining about drainage issues, they would go to the golf course owner and say, you need to fix this. And so the covenants are key as to whether, and the transfer of real property and common areas to the HOA is important to determine whether the HOA is going to be responsible for that. And then, the second question would be, even if there has not been, even if those areas have not been deeded, has the HOA been taking care of those areas? Have they been using assessments to maintain and repair those areas, whether they're common areas or not? If they're common areas, then they should be using the assessments to maintain those areas. And that can be an issue that can come up is, did the HOA properly maintain and repair these areas as they needed it? And is that a cause of why there's flooding or surface water problems, drainage issues? So yes, the bottom line is yes, a HOA may be responsible for drainage problems and legal disputes that come up, but there are a lot of factors and a lot of reasons why they may not be. Another example I'll give you just is you got two lot owners. One's lot is a little bit higher than the other, and the water naturally flows from the one owner's lot to lot owner B's lot. And so lot owner B ends up building a dirt berm between his lot, along the boundary line between his lot and lot A. The question is the HOA responsible for that when the water backs up onto lot A? No, could be and could not be. Again, it depends, because if the covenants say that you're not supposed to make any improvements or changes to your lot without HOA approval, and they're putting in a berm without permission of the HOA, then the HOA may be involved in that process. But ultimately, that's probably a dispute between the two lot owners as to whether the one has the right to build the berm or not. So that's just a quick example of how that can come up. Common, causes of action in this area that may be raised if someone has a problem with drainage or issues in an HOA context, especially if they're saying that the HOA has some responsibility for it. They would, allege breach of fiduciary duty on the part of directors, breach of contractor covenants, especially if there's language in the covenants that requires the ditches and the stormwater facilities to be maintained. The roadways typically are privately owned, and those will probably be under the control, and they may have, gutters, curb and gutter. If they do, that needs to be maintained like the picture shows. If you get allow leaves to pile up in those drainage areas and stuff like that, then that can be a problem. And if that's happening, then somebody might have a claim to that, the HOA is breaching its covenants. There's negligence claims, nuisance claims, and trespass claims. So how can HOAs avoid some of these problems? Well, the directors of HOAs have certain responsibilities to the members. They have the duty of good faith. Basically, that is to act honestly, conscientiously, and fairly toward the membership. They have a duty of due care. They need to exercise due diligence and care and act as a prudent person would in the circumstances. And that includes making a reasonable inquiry into the matters that are at hand. And that's probably the one that deals the most with HOA boards and architectural control committees that function as an agent of the board. Because if the board is not doing its due diligence and the architectural control committee is not doing its due diligence on plans that are submitted and things like that, then it could raise a issue as to whether the board, the association could be responsible for some sort of plans or problems that arise between two lot owners or a lot owner in the HOA. And then the last one is the duty of loyalty, to act in a manner that the directors believe is in the best interest of the HOA. So, if they exercise those duties, then typically they ought to be able to defend whatever actions they're taking. Directors do not need to be right. There's nothing in the law that says they have to be right all the time. But as long as they've made a decision that is reasonable and is based on due diligence and information that they've given, then they're probably going to have found not to be negligent, at least. So, what we tend to leave you all with is avoid the trap, and basically, if you're a property manager, tell your directors to be transparent, to be reasonable, to be accessible, and to be positive. And those are the key letters of trap. And that means avoid the trap. So that's a sort of a 30,000-foot view of water liability rights and stuff like that. And we'd be glad to take any kind of questions from y'all.
Great. Thank you so much, Eric and Amy. We do have a number of questions and we've got about 7 minutes left. So I'm going to start zipping through them. The first question I think can go to Amy. Do you have an idea about the cost of a permit and the cost of the certification of a permit?
I do not. There is a permit fee when the permit's being applied for with the agency, and it depends on which permit route you're going through. There is an express permitting process right now that's available as well, and that information should be on the agency's website. And that's just an application processing fee. But I am not sure what those fees are at the moment. As far as the certification is concerned, I think possibly what question is being asked is how much does it cost to have the stormwater system evaluated and certified to the agency that it's in compliance. And I do not know that. That is something that a stormwater engineer or consulting company that does that sort of inspection would have to provide that cost information. But there's not a cost for the agency to come out and inspect as part of a permit transfer or permit renewal. So depending on what was meant by that question, that would determine fees. If we're talking about an engineer coming out to do the certification and submitting that information as part of that new annual certification compliance that I mentioned as part of the new law, or if it's the agency doing it.
Thank you, Amy. The next one relates to if after the authorities have issued their certificate of compliance or equivalent document that reflects the stormwater device has passed inspection. There's two parts to that scenario. If an issue arises with the stormwater device, what timeline can the HOA require the developer to remedy? And could the municipality also be held liable?
So if the agency has certified that it's in compliance, then I'm not sure that there is a timeline. If it's in compliance, then there shouldn't be an issue with the device. If a device or if an issue arises later, I don't think there is a time period other than as soon as you know about it. And if the developer is still the permit holder and by the terms of the covenants is also still responsible for it, then I don't think that there's like an expiration date. I think it's, you just need to raise that with them once you know. There's a difference between the stormwater permit, which is a contract between the permittee and the state, whether that's the developer or after transfer in the association, and then the covenants, which is a contract between the association and the owners and the developer. So while the permit may say that the developer is responsible for certain things, depending on what the arrangement is under the covenants, the association may or may not need to remedy it, or there may be terms within the covenants that determine how that functions. I don't really see a scenario where a municipality is liable. A municipality may be the governing body in the case of a local stormwater program, but in the situation that's presented, I'm not sure how a municipality would be held liable for an issue with the stormwater device that's within a private community. Eric, do you have thoughts on that?
Yeah, well, let me add to that. I think that first of all, the municipality probably would not be liable. They'd probably have some sort of governmental immunity to that type of a claim. But the way I heard that question being asked, I was a little, I'm not sure I quite understood the question, but it sounded to me like once the permits are issued and things like that, how long can the developer or the person that's installing the system be held accountable for installing it or installing it improperly? And that would be, like if what Amy said is they've issued a certificate of compliance and it's supposedly complies with what the rules are and how it was designed and things like that, it would typically be a 3-year period. Now, if the developer has not transferred control of that over to the HOA yet and is still retaining it, then it's as long as the developer is in control of it, essentially. And it would be 3 years from whenever the problems are first noticed, is typically what the statutes of limitation are. But that's, for litigation purposes. So I'm not sure if that answered your question, but that's what I kind of heard from the question.
Thank you both. In the interest of time, I'm going to pose one last question before we wrap up. How do you handle drainage issues that originate on a private lot but affect HOA drainage?
Eric, I'll let you go with this one first.
So if I understand that question, you've got a private lot that's within the HOA. I'll try to address it both ways. A private lot that's within the HOA that's owned by an owner and it's affecting common areas that are owned by the HOA. Certainly, if that's the case and there's been some sort of changes that have been made by the lot owner then that needs to, the board would need to bring that to the attention of the lot owner and say, you know, the changes that you have made are basically damaging the community's property, and you need to fix that. And, you know, whether they do or not, and the cost of litigation and things like that would play into whether you pursue that any further than that. The other would be if you have an adjoining landowner that's outside of the community that is somehow affecting HOA common property, then, you know, the HOA would again have some sort of an obligation to at least investigate that, find out if the cause of that is of that damage that's happening to the common areas is resulting from the other person's actions, and then basically handle that, you know. So that'd be my answer. I'm sorry that the presentation went away and it threw me off just a little bit.
I'm sorry. Amy, did you have anything to add to that?
Yeah, I hope that answered the question.
Yeah, no, I think Eric covered it.
Okay, great. Well, thank you both so much. We appreciate you presenting today, and thank you to those in attendance. Following today's webinar, we'll send you an email with a list of articles related to the issues discussed today, a recording of the session, a copy of the slide deck, and a link to sign up for our community association's alerts. We appreciate you taking the time to join us. We hope you were able to take the information you learned today and apply it to your own organizations. Thank you again, and that concludes today's webinar.
Thank you.
Thank you for your time.